Hello, classification of trust continued. This is a continuation video on classification of trusts. In the last lesson, I ended the discussion on charitable trusts. Now let's proceed to look at another class of trusts, which is implied or resulting trusts. Implied or resulting trusts. That's another major classification of trusts. So what is implied or resulting trusts? In my lesson on the general overview of the classification of trusts, I classified trusts under the heading. I classified the various trusts. I put them under several heads, and implied or resulting trust, I put it under the head according to how it arises or according to how they are created. I formulated some method of classification for easy understanding, and implied or resulting trust and express trust, constructive trust, I put them under the heading according to, so they can be classified according to how it arises or how they are created, because that will help you to understand their meaning. For instance, implied trusts arise from the intention of the settlor, the same way express trust arise from the intention of the settlor. So implied and express trust, they arise from the intention of the settlor. That is what makes them similar, but there's one difference. Whereas express trust, as the name implies, express, arise from the expressed intention of the settlor. In relation to express trust, the settlor actually expressed intention to create a trust. It is not so with implied trust or resulting trusts. This one arises from the unexpressed intention of the settlor. So implied trust arises from the unexpressed. The intention is not expressed. So if it is not expressed, where does the intention come from? The intention comes from law. The intention is presumed by law. So implied trust arises from the unexpressed intention of the settlor, which is presumed by law. Let's hear from the courts how the courts define implied or resulting trusts. And that was in the case of Adekeye versus Akin Olugbade. Adekeye versus Akin Olugbade Supra. I've mentioned this case before, and I did say that it is actually one of the locus classicus case as to meaning of express and implied trust, and it is one of the earliest cases. Every other cases you will see, they will rely on the definition given in this case. The court in this case gave a simple definition of resulting trust as follows. The court held that resulting trust is a trust founded upon unexpressed but presumed intention of the settlor. Can you see? So implied trust is founded upon the basis, the foundation for implied trust is the unexpressed intention of the settlor. So the roots of implied trust is rooted, is predicated on the unexpressed intention of the settlor. That is, this intention is presumed by law. So there are some circumstances that the law will presume a trust in favor of a donor of a particular property. In favor of a settlor, the law will presume the trust in his favor, and the presumption will be based on his unexpressed intention. That is, the law will presume that that was actually the intention of the settlor when he was doing the particular act that results in the trusts. So it is based on the unexpressed but presumed. It is based on presumed intention. It arises from the presumed intention of the settlor, and this presumed intention is given by laws, and it is a rebuttable presumption. So the law will presume that there is a trust, and in some circumstances it can be rebutted. Now let's proceed to look at some of the circumstances in which resulting trust may be presumed by law. Some of the circumstances where the law will presume implied or resulting trust, or where implied or resulting trust may arise or may occur. Some of the circumstances it may occur. Now take note that because implied trust is based on the unexpressed but presumed intention of the settlor, that it does not now require some of the formalities that is required by express private trusts, because since it is the law that presumes the trust, then the settlor might not have the opportunity to comply with all the formalities, because in this case it is the law that presumes the law in his favor. Therefore, the object of the trusts do not need to be immediately identified, or may not be immediately identifiable, unlike in express trust where the object is required to be identifiable at the time the trust is created. So it may not follow or conform with the formalities required for express private trust, which is based on the intentional acts of the settlor. So what are the circumstances in which implied or resulting trusts may occur or may be presumed by law? There are three major circumstances in which implied or resulting trust may occur. One of the circumstances, number one is where express trust fails. Where there is failure of express trust, there will be implied or resulting trust. Recall that there are circumstances in which express trust will fail. For instance, express trust may fail for uncertainty of objects, or uncertainty of subject matter, or where the weights used by the settlor is not certain. There's uncertainty of weights or intention may lead to the failure of express trust. So in some circumstance, whenever express trust fails, then there will be a resulting trust. The law will presume a resulting trust in that circumstance. So one of the circumstances where implied trust occur is where express trust fails. So for instance, if recall our name for illustration, we have God, we have Sad, we have Long, we have Young. So if God set a trust, God set a trust, but the purpose for which the trust was created failed, then the trust has failed. So, and in that case, there may be a resulting trust to God. There's one illustrative case here. So if the purpose, a particular purpose for which the trust is created, is not accomplished or can no longer be accomplished, then express trust may fail. So if God maybe set up a trust for the education of his child, or for the marriage of his child, but his child end up saying that it will be a eunuch for Christ, that is no longer interested in marrying, then the purpose for which that trust is created has failed, which is for his marriage. And in that case, the express trust set up by God has failed, and there may be a resulting trust to God or to his estate. We have an illustrative case here, which is the case of re-arms settlement, or you may wish to call it re-armis settlement. In that case, it is just similar to the example I've just given. In that case, a father created a marriage settlement. A marriage settlement was created by a father in favor of his son. The marriage was later declared void as a result of the inability of the son to consummate the marriage. It was held that the property resulted back to the father's estate. So in this case now, a father created a settlement for his son, for the marriage of his son, but the marriage failed. It was declared void, was voided by the court, since the son could not consummate the marriage. So the purpose for which the trust was set was for the marriage of the son by the father. You know, there are some parents that whenever a settlement is a trust, it's a trust created by parents for their children who are getting married. So sometimes parents might have the fear that, oh, this my child, a particular parent might have the fear that, oh, this my child that is going into marriage, and I don't want her or him to suffer. I might decide to create a trust for that particular marriage. So that's what a settlement is used for, a trust created by parents for the couples, either both of the couple or any of them. In this one now, it was created by the man's father, and who is the son in this case, and the son could not consummate the marriage. The marriage failed. So it was held that there was a resulting trust. The property, which was the subject matter of the settlement, was held to be a resulting trust to the father's estate. There's one circumstance, and there's one of the common case that is often used or for illustration for this age. Then another circumstance in which express trust fails, in which there will be a resulting trust or implied trust, is where beneficial interest under express trust is not fully disposed. So this one too still has to do with express trust. The first one is where express trust fails. Now again, it is where the beneficial interest under an express trust is not fully disposed or exhausted. So in this case now, if God sets a trust for the education of his son Young, and Young completes his education, finish his education. However, the money that was set aside, that was entrusted, that was held on trust for his education, was not exhausted, still remain. What then will happen to the money? In some cases, the money will be held on trust, on resulting trust to God, who gave the money for the education, because the purpose had been carried out. So where a property remains after the carrying out of an express trust, if a property remain or surplus remain after the purpose for which a particular trust was created, then that property, in some circumstance, the law will presume a trust. The law will presume that the owner never intended the beneficiary to take the surplus. That's what the law presumes. that if the property remain or if there's a surplus, that the owner never intended that the beneficiary should take it beneficially, that's the surplus, but that the settled law intended that it should be held on a resulting trust to him or his estate. So that's why we say that resulting trust is based on presumption. It's the law that's presuming, so it can be rebutted. For instance, now this one can be rebutted where it is shown from the construction of the instrument that the settled law or donor never intended for the property to be held on resulting trusts to him, or that the settled law or donor actually intended the beneficiary to take everything that remained, to take the surplus. So if it is shown from the whole construction of the trust instrument that is what the settled law actually intended, then there will be no resulting trust. So resulting trust or implied trust is based on presumption and can always be rebutted. Now the question is, how will it be known that the settled law or donor intended the beneficiary to take the surplus, to take the property that remain after the purpose of the trust has been carried out? How will it be known? Well, there is no firm or fast rule for determining that. All that is important, or the determining factor, will be based on the construction of the instrument. It is the construction of the instrument that will determine whether the settled law or donor actually intended for the beneficiary to take the beneficial interest. So it depends on the construction that the court will give. That's why in the illustrative cases you may come across, in some cases the court will hold that there was a resulting trust, and in some cases the court will hold that there was no resulting trusts. So the decisions in this regard are not uniform. Let's just see some illustrative cases where there was surplus after the purpose of a trust had been carried out, and it was held that there was a resulting trust. One of the cases there is the case of re-abort. In the case of re-abort, a sum of money was collected from numerous subscribers to be used for the maintenance of two deaf and dumb ladies. On their dates, a surplus remained. It was held that the remaining money was to be held on a resulting trust for the subscribers and not for the benefit of the ladies' estate. So you can see that in this case now, a sum of money was held on trust for the maintenance of two deaf and dumb ladies, and those ladies, unfortunately, they could not remain to enjoy this money which was meant for their maintenance. The question now is the money, the remaining money, going to the estate of these deaf and dumb ladies, or the estate is going back, is resulting back to the subscribers? It was held that the money is to result back to the subscribers. So there's an example where beneficial interest is not fully exhausted or disposed. Another case is the case of Gwungmijana Boss Disaster Fund. So in Gwungmijana Boss Disaster Fund, in that case, a large number of people subscribed to a trust fund set up for 1, to care for those injured in an accident, 2, thereafter for worthy causes in memory of those killed. So these two categories of trusts, two objects. The first object is to care for those injured in an accident. Then the second one is thereafter for worthy causes in memory of those killed in that accident. Now, a surplus remained after carrying out the first purpose, and the second purpose failed as it was not exclusively charitable. It was held that despite the obvious inconvenience that would occur, the surplus money must be held on a resulting trust for all the subscribers in proportion to their contributions. You can see how far the court have gone in this case to hold that there was a resulting trust despite the inconvenience, because this particular trust fund was subscribed to by different categories of persons. But the court still insists that the surplus must be held on a resulting trust to them, despite that it might be difficult to actually find them. There is also the Nigerian case of Riobabumi Pedro Supra, which has been mentioned before. Is an illustration of a resulting where it was held that there was a resulting trust. In that case now, money was actually money was actually held on trust. Certain property was held on trust for the education of the children and grandchildren of the testator. And after all the testator children had died, the only surviving grandchildren were sui generis and had completed their education. The trustees brought an action to determine what was to be done with the property. Gwungmijana, as it then was held, that on true construction of the will, the gift was not an outright or absolute one to the children and grandchildren, but was for the specific purpose of educating them. Since that purpose had been carried out, there was resulting trust to the testator's estate. So you can see another scenario and a case where the court held that there was a resulting trust. So this case now, the testator gave a certain property to be held on trusts, and the rent therefrom from the trust should be used. One of the purpose is that it should be used for the education of children and grandchildren. And now, after all of them completed their school, the trustees were the one that brought the action for the court to determine what is to be done with the remaining amount of money. And His Lordship of blessed memory, Udoma, held that there was a resulting trust, but a contrary decision was given in the case of Andrew's trusts. A contrary decision was given in the case of Andrew's trusts. In that case, a surplus remained after the children had all reached majority and completed their education. So in this case also, a trust fund for the education of children of the deceased clergyman was subscribed by a number of people, and a surplus remained after the children had all reached majority and completed their education. It was held that no resulting trusts. So in this case, it was held that there was no resulting trusts, that the children were entitled to take the surplus beneficially in equal shares. So you can see that the decision of the court sometimes may not be uniform. So it depends on the construction given by the court. The last aid or circumstance in which a resulting trust occur or may arise or will be presumed by the court is where there is purchase of property in the name of another, where there is purchase of property in the name of another. So in this case now, if God purchased property in the name of loan, that is, God provided the purchase money, and however the property was conveyed to loan, or the conveyance was done in the name of loan. That's the deed of transfer or assignment or whatsoever, the relevant documents. It was Long's name was bearing Long name. The law presumed that Long is to hold the property on trust for God who provide the purchase money. So whenever a person advances or provide the purchase money for the purchase of a particular property, if it is a person that provide that purchase money, however the property was conveyed to another person, there will be a resulting trust. It could be maybe a receipt. The receipt was issued in the name of another person. It is maybe his brother or another person, his friend, that the receipt bears, his name friend that the receipt is bearing. But let's use land for example. So if a person provide the purchase money for a land and the conveyance, the deed of conveyance or deed of transfer was done in the name or prepared in the name of another person, the law presumes a resulting trust in the name, in favor rather of the person that provided the purchase money. This is what this aid is all about. Provided it is shown that the property is not intended to be a gift. Provided it is shown that the property is not intended to be a gift to the person in whose name the property was conveyed. So this particular aid is simple and practical. So sometimes you might, for whatever reason, you bought a property, but the property is not conveyed to you. The documents, you decided to use your friend's name. The law presumes that your friend is to hold, if you don't intend that the property should be a gift to your friend, the law will presume that your friend is to hold that property on resulting trusts to you. So your friend become a trustee. He will hold the property on trust to you. So once property is purchased in another person's name, you purchase a property but in the name, not in your own name, in the name of another person, there's a presumption of resulting trust in your favor. Don't worry, don't be afraid, provided it can be shown that you never intended for that property to be a gift to the person in whose name the property was purchased. That's what the law is saying here. So there will be a resulting trust. So the same thing, the same rule apply where a person pays the rents for a lease, but the renewal was done in another person's name. So if a person provide the purchase money for a lease, however, when the lease is to be renewed, it was done in another person's name, then there will be a resulting trust for the person that provide the purchase money. And that's what happened in the case of Okata versus Emembo. Okata versus Emembo. There, the fees for the renewal of a lease was paid by the plaintiff, but the renewal was obtained by the defendant in his own name. It was held that that a resulting trust arose and the defendant held the new lease as a trustee for the plaintiff. So it was the plaintiff that provided the money for the renewal of the lease. However, the defendant took the lease, obtained it in his name. The court held that that there was a resulting trust and that the defendant owed it as a trustee to the plaintiff that provided the money. So the overriding factor or determining factor in this trust is who provide the purchase money. That's the first thing. The second thing, the person that provide the purchase money, did he intend the property to be a gift to the person in whose name the property was purchased, or the person whose name the relevant document, whose name is appearing on the relevant document? That's the question. So if all those questions is in the negative, then yes, for this trust to arise in the favor of the person who wants the court to declare the trust in his favor, that's who actually provided or who is claiming to have provided the purchase money, must actually proved that he provided the purchase money. For if he cannot prove his claim, will fail, as in the case of Madu versus Madu. So that's what happened in Madu versus Madu, where between husband and wife, the man claimed that he was the one that provided the purchase money. When their relationship became strained, that was when this case arose. But he could not, that the wife was holding the property on a resulting trust to him. But he could not prove that he actually provided the purchase money. So his claim failed. In that case, the court explained this presumption of resulting trust in the following word. The court stated, and I quote, "The court will impel or presume a situation where a purchase of property is made in the name of another, that the other hold the property for the benefit of the person who advanced money for the purchase of the property. The law in such a situation presumed that the intention was that the property should be held on trust by the third party transferee." So the person in whose name the property was done in favor, the law will presume, there's a presumption that is to hold it on trust for the person that actually advanced the purchase money. So the court further stated that the same principle apply even where the purchase money was provided partly by the transferee and partly by others. So if the person, if it is more than one person, now it is more than two, it is more persons, and they all contributed the money. However, it was done, the property was purchased in the name of one of them. That person, that transferee, the person in whose name the property was purchased, will still be regarded as a trustee to the other person, because his money, he only advanced parts of the money. So even where people contributed money and the property is purchased in the name of just one person, the person is holding that property on a resulting trust. The presumption will still arise in that case. So take note that it is not actually wrong to purchase property in the name of another person, your own property, in the name of another person. However, the exception is if it is for illegal purpose. If the purchase is for illegal purpose or for fraud, maybe for instance, there are some government officials that are not required to, have some certain property, they will now use the name of another person. So that one is for an illegal purpose and it's for fraud. In that case, there will be no resulting trusts because equity will not, he who comes to equity must come with clean hands. So equity, you cannot benefit from your own wrong in that case, estopic causa. So while it is not wrong to purchase property in the name of another person, there is danger in it, and the court warned about this danger in that case of Madu versus Madu. In that case, the court per Mohammed JAC stated the danger where a party uses the name of another person in transaction in party's favor. So the court stated the danger in using another person's name in a transaction that is in your favor, whereas it is not wrong under the law, but there is danger, and the court stated the danger as thus. Per Mohammed JAC added to say on the risk involved in such a transaction. He stated, before I drop my pen, I think I should observe this case. As I see, it should be an eye-opener to many. Although it is not illegal or prohibited to make use of another person's name in transaction that are solely meant to be in favor of a particular individual, I think it carries a lot of risk where there is a failure in achieving the goals for which the transaction is meant. So if maybe when you actually purchase the property, or there's actually a reason why you want the transaction, the purchase to be in the name of another person, and that goal is not finally achieved, then there will be a problem. There's the problem, the circumstance in that case of Madu versus Madu Supra. So there's the warning of the court there. It is not wrong, but there is a risk in it. Take note that there's under this age, there's exception to resulting trust whenever property is purchased in the name of another. The exception is what is referred to as the presumption of advancement. So you can read that further. Time will not allow us to briefly talk about, but it serves as an exception. It's generally where the person in whose name the property is purchased is the wife, if it involves the relationship of husband and wife, or father and child, then there's presumption of advancement that the property is actually a gift to that child, or if it is a person in whose a person is in loco parentis, then there's presumption in favor of that child, or if it is a wife, in favor of that wife. So there's presumption of advancement, which is an exception. I will end this discussion here. So subsequently we shall now look at the other class of trust, which is constructive trusts. Thank you, and see you then.